of that, now let us go to the exciting part. How, no, hindi naman talaga exciting, the convoluted part. How is a corporation formed? We have to thresh, through the different components of a corporation. Of course, a corporation is the sum of its parts. And so in order for us to gain a deeper understanding of how a corporation ticks, how it works, we have to be able to identify its different parts. First off, the incorporators. Diba, napapansin na ninyo, so far in our session tonight, nakakailang reference na ako sa incorporators. Ngayon, makikilala na natin sila. Incorporators are these persons mentioned in the articles of incorporation as originally forming and composing the corporation and who are signatories thereof. So sila yung original members. Among themselves, they decided to form a corporation. So sa articles of incorporation, nandoon ang kanilang mga pangalan at pirma. Incorporators may be an incorporator may be a natural person, of course, of legal age. A partnership can be an incorporator. Another corporation can also be an incorporator. In fact, even a foreign corporation subject to certain qualifications under under the SEC memo na to, Memorandum Circular number 16, series of 2019. Of course, the exception here would be one-person corporations. In an OPC, the incorporator, yung nag-iisang solo incorporator can only be a natural person or a trust or an estate. One of the another series of new improvements to the corporation, to the law on corporations ay dati kasi mayroong residency requirement for incorporators. Kailangan residents of the Philippines lang. Pero ngayon, under the revised corporation code, there is no more residency requirement. Now, an incorporator, in order to be an incorporator, must subscribe to at least one share of stock. So lahat ng incorporators na yan, at least one share, meron sila. As a general rule, like we mentioned earlier, there has to be at least 2 incorporators. Though dati, meron niyang ceiling minimum of 2, maximum of 15. Pero parang ngayon yata, wala na siyang ceiling. So, can be as many as you want. But of course, by way of exception, in an OPC, there is only one incorporator. Now, nasabi na natin kung ano yung incorporator. Meron ding tinatawag na corporator. Take note magkaiba to. Iba ang incorporator sa corporator. When we speak of corporators, we refer to all the stockholders and members of a corporation, including the incorporators who, by virtue of their possessing at least one share of stock, are considered stockholders. So ibig sabihin, kapag ikaw ay bumili ng isang share of stock ni V-Right, ni Manny Villar, pag natuloy na yung IPO nila, yung kanilang initial public offering, you are already a corporator. Kasi lahat ng stockholder, whether the stock in your possession is a voting stock or a non-voting stock, kahit na wala ka namang say sa management ng partner ng corporation, you are already a corporator by mere virtue of you being a stockholder. Now, what are stockholders and members? A stockholder is a person who holds or owns shares in a stock corporation. Meanwhile, members are those who compose a non-stock corporation. So pag stock corporation, stockholder. Pag non-stock corporation, member. All right? Again, pag non-stock corporation, member. Pag stock corporation, stockholder. Yan. Now, what are directors and trustees? We now go to the board of directors or the BOD. The board of directors is the governing body in a stock corporation. Meanwhile, the board of trustees is the governing body in a non-stock corporation. So pag stock corporation, directors. Pag non-stock corporation, trustees. No, both the board of directors and the board of trustees exercise the powers of the corporation. Any corporate powers, sila ang nagpapatakbo. Sila yung nagdedesisyon. Okay, as a general rule. Now, what is a promoter? A promoter is a self-constituted organizer who finds an enterprise or venture and helps to attract investors, forms a corporation, and launches it in business, all with a view to promotion profits. You see, sometimes kasi, hindi naman lahat ng mga people, na interesadong bumuo ng korporasyon ay kasing galing ni Manny Villar. These newbies, no, these neophytes, so to speak, they secure the aid of an expert. So this expert will help them go through the motions of forming a corporation, helping them attract interest in the business, kagaya ng ginagawa ni Villar. Si Villar, hindi niya kailangan ng promoter. He is his own promoter. So si Villar, siya mismo nagsasabi na ito ang kayang gawin ng aming ni V-Right, no? Ito yung aming assets. This is the number of our shares that we will be selling in our IPO. Pero kung hindi ka ganun ka-competent, kung hindi ka kasing competent ni Manny Villar, it is the promoter that will do all of those things for you. No? Ang kapalit, of course, you have to pay the promoter in the form of what we call promotion profits. Of course, no? Dahil nga si promoter ang basically nagbe-babysit dun sa korporasyon, pwedeng mangyari na itong si promoter pumasok sa isang kontrata supposedly in the name of the corporation. Now, of course, if the corporation has already been incorporated, may na-issue ng certificate of incorporation, that's well and good. Wala namang problema doon. But the thing is, paano kung yung kontrata na pinasok ni promoter, pinasok bago nakapaglabas si SEC ng certificate of incorporation? Sa madaling sabi, dahil wala pang certificate, wala pang corporate life, wala pang korporasyon. Okay? In that case, in that situation, the corporation will not be bound by the contract entered into by the promoter. Unless, of course, pwedeng i-ratify naman ito ng Board of Directors ng korporasyon. According to Cagayan Fishing Development Corporation Incorporated versus Sandico. Now, the promoter is obliged to remit or to return to the corporation profits that he derived that properly pertains to the corporation. Ang pwede lang makuha ni promoter ay yung tinatawag na promotion profits. Yun lang. Yung lahat ng pera na pumapasok with the aid of the promoter that should redound to the corporation, dapat sa korporasyon yun mapupunta. Hindi siya pwedeng i-hold ni promoter. Now, of course, every corporation has a name. Obviously, no? As outlined in Section 17 of the Revised Corporation Code. A corporate name, for that matter, must be distinguishable from that already reserved or registered for the use of another corporation. Think of it this way. Panigurado naman, may nagmo-Mobile Legends naman sa inyo, or anybody here who has tried to play an online game or something where you have to enter a name. Tapos, may naisip ka na cool na pangalan na ito gusto kong pangalan. Tapos, sinubukan mo na you type in the name that you thought was cool only to be met with an error message. This name is already taken. Ngayon, syempre, banas ka. Ano ba yun? Mag-iisip pa ako ng bago. Pero yun nga, wala kang choice because the name was already taken by another person before you. Ganon din for corporations. The name must be distinguished or distinguishable from the names of the already existing corporations. Kailangan unique, no? Because there is a ano bang tawag dito? There is a looming concern and there is a big problem, no? That would come with the name of a new corporation being so similar to that of one already in existence. Now, take note, the addition of these words, corporation, company, incorporated, limited, limited liability, or an abbreviation of these. Corporation, pwedeng corp or co, diba? Same with company, co, incorporated, inc, limited, ltd, limited liability, yung mga LLC, no? Or punctuation, marks, tenses, articles, conjunctions, etc., spacing or numbers will not by themselves make a name distinguishable. Just an example off the top of my head. All of you have heard of the band Panic at the Disco. Now, of course, Panic at the Disco is not a corporation. It is a partnership like any other band. No? A limited liability partnership. At some point in time, no, during the mga siguro after the first 3 years of their career, di ba Panic at the Disco is spelled panic, exclamation point at the disco, right? At some point in the band's career, they dropped the exclamation point. Ngayon sabihin natin, so that's just Panic at the Disco, no punctuation. Merong bumuo ng banda, tapos ang pinangalan nila sa kanilang sarili Panic, exclamation point at the Disco. Now they are saying na ibang pangalan naman to kasi the original Panic already dropped the exclamation point doon sa kanila. And therefore, magkaiba naman yun doon sa merong exclamation point. Surely the inclusion of this punctuation mark will render our name different from Brandon Urie's band. No? But of course, if we follow, in the context of corporations, if we follow the revised corporation code and applicable case law, kahit na dagdagan mo yan ng maraming punctuation marks, kahit na dagdagan mo pa yan ng special symbols, no, by themselves, this will not make the name distinguishable, especially if meron talaga siyang kaparehong pangalan in existence. Now, of course, SEC being the regulatory agency that governs all business organizations, SEC has the power to compel a corporation to cease and desist na patigilin ng isang korporasyon from using a distinguishable or illegal name. And of course, to remove any signages, any marks or advertisements. So kung meron silang billboard, no, or tarpaulin na nakalagay doon yung kanilang illegal or distinguishable na pangalan, pwedeng ipatanggal yan o ipatibag ng SEC. And to compel this corporation to register a new corporate name. So illegal name. So hindi ka pwedeng maglagay ng pangalan na ano ba to? Ano ba tong clan na instigator nung Marawi conflict? Maute. No, for example, Maute yung pinangalan mo sa korporasyon mo. It would that name would instigate further conflict. And therefore the SEC has the power to tell you na, huy, palitan mo pangalan mo. No? Now, here's an example. Meron ba sa inyo na nakapunta na sa Bicol or merong mga kamag-anak sa Bicol? Or nakabisita na sa Bicol, no? If you have, you may have heard of the restaurant named Biggs, no? If the rest of us here in the country know of Jollibee, of McDo, etc., etc., Bicol, Region 5 is unique in the sense that they have their own local fast food restaurant, the popularity of which rivals Jollibee. No? Sa Bicol, meron silang Biggs. Biggs restaurant is operated by the corporation named Biggs Incorporated. Now, Biggs Incorporated operates the leading food chain in Bicol, which has the same name, Biggs, with 14 branches in the region and one branch in Lipa, Batangas. Biggs Incorporated was founded in 1983 by 3 enterprising women, and it started out as a small takeout counter which sold burgers and fries. Do you know that if you've tried or if you've seen Biggs, before, you may or may not know that this restaurant actually went by a different name when it was first established in 1983. Ang pangalan niya, ang una niyang pangalan ay McDonald's. Yeah, that is unfortunately not a joke. There was a restaurant back in the day, back when McDonald's was already operating here in the Philippines. No, there was such a restaurant named McDonald's. No, this was a subject of a post I uploaded in LinkedIn back when I finished the intellectual property law webinar by the Intellectual Property Office. There is this case kasi discussed in intellectual property law. I don't know if this was covered in your Law 102. No, I think IPL is part of the subject matter there. One of these stable IPL cases is the case of McDonald's versus McJoy. A February 2, 2007 decision of the Supreme Court. Ganyan ang issue. McDonald's sued McJoy, a restaurant in Cebu. No, because the allegation is that McJoy, the name McJoy, is indistinguishable from the name McDonald's. Now, the thing about Biggs is that they managed to evade getting sued. Okay? So yun nga, like I mentioned earlier, in 1983, Biggs started out as McDonald's. Naisip siguro nung tatlong binibini na bumuo nitong McDonald's, na-realize nila na they have to make their branding more distinct. Kasi if you name your restaurant similar to a bigger restaurant, you run the risk of, staying in that bigger restaurant's shadow forever. You have to aim higher. So they swapped their name McDonald's with Carl's Diner back in 1990. And later on, they changed the name of the establishment another time, this time to Biggs in 1994. And the name stuck. Kilala sila ngayon as Biggs, the biggest fast food restaurant in Region 5, almost rivaling or perhaps second only to Jollibee. Now, of course, buti na lang, napalitan nila in 1994 kasi by 1996, nagsimula nang magsampa ng kaso si McDonald's sa mga restaurant, sa mga establishment na may pangalang katunog ng or kapareho ng McDo. Which included, of course, the McJoy restaurant in Cebu. Now, of course, unlike McDonald's, which later became Carl's Diner and then later Biggs, Biggs still exists today, still going strong today, despite the pandemic. We cannot say the same about McJoy. Nalugi si McJoy, I would think. At present, there is a restaurant named McJ, not McJoy. A restaurant in Rizal, in San Mateo, Rizal. Na mataas ang reviews sa Google. 4.0 out of 6, 4.0 score out of 5 out of 69 reviews. But of course, this McJ is not McJoy. Kasi McJoy is from Cebu. And apparently, nung sinampahan sila ng kaso ni McDo, umabot yung kaso sa Supreme Court as to the question of whether McJoy is distinguishable or indistinguishable from McDo. Siyempre, kinampihan ng Supreme Court si McDo, and apparently, kinain na ng lupa si McJoy, never to be seen again. So, now you see, I hope you see how important the distinguishability factor of a name is, especially in the context of corporations. Diyan papasok yung creative acumen ng team or ng incorporators. You have to come up with a name that is unique, no? Hindi kagaya ng lahat ng nasa merkado ngayon. You have to come up with a name that has good recall. No? Now, we now move forward to the articles of incorporation. We have referred to this a number of times already tonight. At sinabi natin na ito yung dokumento or yung series of documents na kailangang isubmit sa SEC when the incorporators apply for, the issuance of a certificate that would allow their corporation to finally get off the ground. So ano ang dapat na nilalaman ng Articles of Incorporation? According to sections 13 and 14 of the Revised Corporation Code, the Articles of Incorporation should contain the following. First, of course, the corporate name. Then, the specific purpose or purposes for incorporation. So if this is an educational corporation, you mention that you intend to construct, operate, and maintain a school. Or if this is a corporation for the construction and maintenance of a hospital, you also state as such. Now, if it is a profit-making venture, sabihin natin korporasyon ang focus paggagawa at pagbebenta ng sabon, sasabihin mo din doon sa articles. Next, you mention the place where the principal office will be situated within the Philippines. And then the term of corporate existence. Kung perpetual, kung gusto mong walang hangganan yung korporasyon mo, you mention that. If not, kung gusto mong limited lang yung existence niya, you also make mention of it. And then you identify who the incorporators are, no? Their names, their nationalities, their addresses. Now, you also specify or indicate the first batch of directors or trustees. No? The directors have to be at most 15 individuals, no? Maximum number of 15 directors. Or in case of trustees, for a non-stock corporation, pwede more than 15. After that, no, you indicate the names, nationalities, and addresses of persons who shall act as directors or trustees until these regular directors na pinangalanan mo dito, until the time that they would be able to assume their duties, until the time that they would be duly elected, sino yung mag-handle ng duties of the directors or the trustees, you have to identify these persons. For stock corporations, you have to specify the amount of authorized capital stock, the number of shares into which it is divided, the par value of each, the names, the nationalities, and the addresses of the original subscribers or the original stockholders, at kung magkano yung value ng stock or stocks na kanilang hawak. Or if applicable, no, kung mayroong mga stocks na walang value, walang par value, you make mention of it. Like for example, kay Villar doon sa V-Right, di ba? Alam natin na milyon-milyon yung shares. Kasi kailangan naka-indicate yun sa Articles of Incorporation. At alam din natin kung magkano yung value ng mga shares at least for purposes of initial offering. Di ba? Wala pang 3 piso, 250 per share. Kailangan naka-indicate yan sa Articles of Incorporation. For non-stock corporations, of course, dahil walang stock, you just make mention of the amount of capital. So magkano yung capital ng korporasyon na to? As well as the names, the nationalities, and the addresses of the contributors. Kung mayroong mga nag-contribute para mabuo o para makuha itong kapital ng non-stock, kailangan naka-identify sila. Sino-sino ba itong mga taong ito? Ano ang kanilang nationality? Saan sila nakatira? At magkano yung kanilang contribution? Kung mayroong arbitration agreement, in other words, ito ay isang clause in a contract, no? Or in this case, in the Articles of Incorporation, stating kung saang lugar o kung saang tribunal ihahain ang anumang kaso kung mayroong hindi pagkakasundo among the incorporators or among the directors, among the corporate officers. Diyan nakalagay yan sa arbitration agreement. Kung meron, you include that in the articles. Finally, any other matter consistent with the law in which the incorporators may deem necessary and convenient, kung meron pa silang gustong idagdag, as long as pinapayagan ng revised corporation code, pwedeng isingit or isama sa articles. Now, you are seeing in your screen right now a reproduction or rather a screenshots of section 14 of the revised corporation code. So this is the first part, itong may number 1, and then the other part, itong number 2. So sa section 14, naka-reproduce yung template ng Articles of Incorporation. So makikita natin, no? Articles of Incorporation dito ilalagay yung corporate name, as well as dito sa first clause that the name of the said corporation shall be blank Inc. Yan. Corporation or OPC. So kung one person corporation yan, kailangan mong blankohan to o bilugan to or i-highlight yan. Purpose, no, or purposes, you mentioned that. The principal office at kung saan siya makikita. Kung perpetual existence, i-highlight mo lang blank one or bilugan yung perpetual, you just leave this blank. Or if you want a limited term, you mention kung gaano katagal, the names, nationalities, and residences of the incorporators, the number of the directors, so maximum of 15 for directors, for trustees, pwedeng more than 15, and then their names, their nationalities, and their residences, yung authorized capital stock kung magkano, divided into how many shares, with the par value of how much. So 333 billion, no, in shares divided into blank shares with the par value of how much. And no, that the capital stock of the corporation is kung mayroong mga shares na walang par value, you mention here. Now, no, number of shares have been subscribed as follows, kung sino yung mga initial subscribers or initial stockholders at kung gaano karami yung kanilang shares. Now, no, kung sino ang naka-hold over na mag-exercise ng powers of the treasurer of the corporation, nakalagay sa 9th clause. Sa 10th, no, may 10th clause, the incorporators undertake to change the name of the corporation upon receipt of notice that another corporation already has that name. So kung hindi siya distinguishable, the 10th clause is a commitment on the part of the incorporators na babaguhin namin ito agad-agad once na we receive feedback from the SEC na mayroon nang may pangalan nito. 11th, no, corporations which will engage in any business or activity reserved for Filipino citizens, like for example, if this corporation will be in the business of mass media, kailangan may nakalagay, no, na itong caveat na to, na this is a commitment na yung nationality requirement, yung 60-40 requirement, susundin. Okay? In witness whereof, yung petsa, kung kailan siya natapos, yung kung kailan siya na-accomplish itong document na to, araw, buwan, taon, kung saang lugar, kung saang probinsya, yung mga pangalan at pirma ng mga incorporators at yung pangalan at pirma ng treasurer. Now, of course, the articles of incorporation may be submitted electronically or online, as well as it can also be amended. So kung mayroong issue, like 'di ba in the case of a de facto corporation, kung mayroong mali doon sa articles, pwede naman siyang i-correct o remedyohan. Which of course, if we are talking about a de facto corporation, once na ma-correct yung error, then it will have de jure status. Now, we are looking at the e-SPARC, no? This is the electronic simplified processing of application for registration of company. This is an online facility provided by the SEC to cater applications for registration of any corporation, whether it is a domestic stock corporation or an OPC. You can submit your articles of incorporation through this method or through this portal. Now, of course, once the articles are submitted to the SEC, dalawa lang naman ang magagawa ng SEC. The SEC will either approve the application or disapprove it. Now, what are the grounds for disapproval? Section 16 will provide us the answer to that. If the articles are not substantially in accordance with the form, akalain mo, meron ng form, may template na nabinigay sa Section 14 tapos hindi mo pa susundin. So, kung merong variance ng material, kung merong material information na hindi nasabi, pwedeng i-disapprove yung articles. Or if the purpose or purposes patently unconstitutional, illegal, immoral, or contrary to government rules and regulations. Gusto mo magtayo ng korporasyon na magbebenta ng ano ba to? CBD, no, parang I think CBD is liquid tetrahydrocannabinol or liquid cannabis. No? So of course, bawal yun dito. Sa states pwede yun, pero bawal yun dito. So if the purpose is that, bebenta ka ng CBD sa Pinas, that's illegal. And therefore, that is a ground for the disapproval of your articles of incorporation. Next is if the certification containing the amount of capital stock subscribed and or paid is false. Sinabi mo na bilyones yung inyong capital stock pero actually upon review by the SEC, hindi naman. So that can also be the basis for the SEC to disapprove your articles. Now, if nationalized yung industry na papasukin or protected by the Constitution, sabihin natin mining, tapos makita ni SEC na bakit parang ang majority ng stock nitong korporasyon na to ay foreign owned in contravention of the constitutional guarantee na kailangan majority Filipino owned. No? Pag ganun, pwedeng i-disapprove din ng SEC yung articles of incorporation. Now, with regard to banks, banking and quasi-banking institutions, pre-need insurance and trust companies, pawn shops and other financial intermediaries, maliban doon sa articles of incorporation, meron pa silang additional na dapat ipasa. There must be a favorable recommendation from their corresponding regulatory agency. Ang regulatory agency for banks and other similar institutions ay ang Bangko Sentral ng Pilipinas. So kailangan may naka-attach doon sa articles of incorporation nila na favorable recommendation in writing from BSP. For insurance companies and other trust companies, the regulatory agency is the Insurance Commission or the IC. So pag ganyan, ang korporasyon na binubuo, kailangan meron ding in writing na rekomendasyon from IC to the effect that such articles of incorporation or such amendment to the articles are in accordance with the law. Yan yung dapat laman ng recommendation. Pag wala yan, then the articles may be disapproved. Now, no? Ano ang ine-entail o ano yung mga steps? Now that we have already outlined kung ano yung particulars in the process of forming the corporation. Ngayon, pasadahan na natin yung takbo ng process as outlined in Section 18 of the Revised Corporation Code. First, no, you double check muna with the SEC if your corporate name has any kapareha. You ask the SEC to verify. Now, if the SEC finds that the name is distinguishable, kung unique yung pangalan mo, wala kang kagaya, hindi yan parang MacJoy na sounds like MacDo, then the name shall be reserved. The SEC will reserve the name for you. Now that the SEC has already reserved the name in your favor, now you and your co-incorporators should now submit your articles of incorporation with the SEC, along with other necessary documents. Ano yung mga necessary documents na yon? If bangko ang gustong buuin ng korporasyon, a favorable recommendation from BSP. If insurance company or trust company, recommendation from IC. Now, of course, pwede kang magdagdag ng additional documents supporting yung actual value ng capital stock mo. Kung gaano supporting documents to show the SEC na ganito talaga karami yung shares of stock na meron kayo. Ganito talaga karami o kalaki yung kapital ng business, di ba? You attach all of those sa articles of incorporation. You submit everything to the SEC. Now, if upon review ng SEC at nakita nila na fully compliant ka, the SEC shall then issue the certificate of incorporation. And it is only upon that issuance, only at that point in time, that the corporation will begin to exist. All right? Now, let us presume that the certificate of incorporation has already been issued. Hindi ibig sabihin niya na hindi na pwedeng galawin ng SEC yan after the fact. Because the SEC has the power to suspend or revoke a certificate of incorporation upon a finding by the SEC that any of these grounds exist. Now, the guiding provision here is Section 6, sub-item L of Presidential Decree number 902-A, also known as the SEC Reorganization Act. Basically, the law that outlines the powers and responsibilities of the SEC. Now, number one, if there is fraud in procuring registration, kung nalaman ng SEC later on na mayroong kasinungalingan na inilagay doon sa articles, or if there is serious misrepresentation as to the objectives of the corporation. For example, sinabi mo na kayo ay magbebenta ng mga beauty products, pero yun pala, direct selling pala yung business ninyo, masquerade na minamasquerade, ang tunay na intention pala ay mag-operate ng MLM. So there is misrepresentation as to the purpose, as to the objective. Sabi ninyo, magbebenta kayo ng mga health and beauty products, pero MLM pala to, di ba? That is a ground for the suspension or revocation of a certificate of incorporation. As a matter of fact, no, teka nga. Meron yan a SEC issuance with regard to One Lightning. Banas na banas kasi ako dyan sa One Lightning na maraming naloko na mga tao. No? Ito. Let me check. Kailan nga yan in-issue? So medyo matagal na yan for sure. Ayun, yan. Finally. Let me switch my screen. Let me share to you. Ito, si One Lightning Corporation. This is an order issued by the SEC, no? Filed by the Enforcement and Investor Protection Department of the SEC itself against One Lightning Corporation. Ang sabi ni One Lightning sa kanyang articles of incorporation, ang primary purpose niya ay, if I may quote, to engage in the business of buying, selling, marketing, and distributing of goods such as coffee, juice, tea, food supplements, beauty products, soap, lotion, perfume, cosmetics, organic finished product, and products of all kinds and description in wholesale and retail basis. No? However, as you know, naimbestigahan ang One Lightning at nalaman na iba pala ang purpose ng kanilang business. Diba? Investing. Ito, Cristina Pascual explained the business of the corporation and how much one could earn by investing. Okay? Let me see. Itong part na to dito. Clearly, One Lightning is engaged in the sale or offering for sale of distribution within the Philippines of securities. In other words, investment contracts based on the statements made by Cristina Pascual, the PowerPoint presentation and Facebook account of One Lightning without a registration statement duly filed with and approved by the Commission in violation of Section 8.1 of the SRC. Ito, tignan pa natin yung iba dito. In fact, the products available in the executive package, ibale, apricot scrub, Mekauri whitening perfume lotion, units of pure glow soap for the amount of 195 units ng scrub, 408 units ng lotion, at 360 units ng soap. Hindi siya dapat, I mean, kung generic brand yung pinag-uusapan natin dito, malabong aabot yan ng 766,500 pesos. Kaya sabi ng SEC, overpriced. It appears to be overpriced. A reasonable-minded person will not pay 766,500 pesos for such products. So basically, ang sinasabi ng SEC dito, hindi naman talaga kayo nagbebenta ng beauty products o ng health products as opposed to what you stated in your articles of incorporation. In fact, ang binebenta ninyo ay securities, 'di ba? Binebentahan sila ng package na by which you buy this package, you will be given a given shipment of products for you to sell, allegedly sell, Pero actually, ang talagang dapat mong gawin is to convince other people to also buy, no? To also buy securities, no? You refer, no? So kailangan mo ng downline. Kailangan mong mangumbinse. Yung pagbebenta naman talaga, hindi naman yun talaga yung main purpose ng business. Kaya pag ganun, no? That is a ground for the suspension or the revocation of the articles of incorporation or the certificate of incorporation pala rather, which is what happened to One Lightning. Kaya wala na sila ngayon. Of course, if the corporation refuses to comply with a lawful order of the SEC, hindi sumusunod, hindi masunurin, the SEC can of course suspend or revoke the certificate of incorporation of that erring corporation. Failure to file reports kasi the corporation should comply with reportorial requirements. Kailangan nalalaman ng SEC kung ano yung nangyayari sa korporasyon. If there is a failure in that regard, then of course, the SEC can also revoke or suspend the certificate of incorporation as well as other similar grounds. Next, no, I think dito na sa area tayo titigil for this topic. Non-use of corporate charter. Minsan kasi mayroong mga korporasyon na nag-apply sila for a certificate of incorporation, na-issuean sila ng SEC, pero for one reason or another, hindi naman sila nag-push through sa kanilang business. Whether kasi na biglang nawala ng funds o di kaya kagaya nitong nung nagkaroon ng unang sigwada ng COVID-19 dito sa Pilipinas, no? So hindi nakapag-implement ng kanilang business. Under our law, no, if a corporation does not formally organize and commence its business operation within 5 years from the date of incorporation, in other words, the issuance of a certificate of incorporation, the certificate shall be deemed revoked as of the day following the end of the 5-year period. So 5 years, walang nangyari, walang business na binuksan. Pag stock corporation, walang stock na in-offer for sale to the public. The first day following the 5 years, the SEC will revoke or rather automatically deemed revoked na yung certificate of incorporation. Now, no? That is kapag na-issue yung certificate pero walang business talaga na nabuo. Pero if a corporation has commenced its business naman pero biglang nalugi, no? Nag-go under and has subsequently become inoperative for at least 5 consecutive years, the SEC will conduct hearing, no? The SEC will notify all parties, and then if warranted, the SEC will place the corporation concerned under what we call delinquent status, delinquente na korporasyon. The delinquent corporation will be given 2 years to resume operations. Basically, 2 years to get your business up and running again, as well as to comply with any requirements imposed by the SEC, any other requirements. Now, kapag nagawa ng delinquent corporation na ibangon yung kanilang business within the 2 years, then the delinquent status will be lifted. If not, then of course the SEC has little recourse but to revoke the certificate of incorporation. Kasi no point. What's the point? Hindi naman niya nabangon sarili niya. Hindi naman nagawang ibangon ng korporasyon yung kanyang business. Hindi na siya naka-recover. Then of course, at that point in time, the revocation of the certificate of incorporation is practically a mercy killing already. Now, sige, tapusin lang natin tong bylaws. 8 naman tayo nag-start. Bylaws are governed by sections 45 to 47. Bylaws are relatively permanent and continuing rules of action adopted by the corporation for its own government and that of the individuals composing it and those having the direction, management, and control of its affairs, in whole or in part, in the management and control of its affairs and activities. This is a definition espoused by the Supreme Court in the case of China Banking Corp versus CA in its decision back in 1997. Paikliin natin. Ang sinasabi lang naman ng Supreme Court dito is that bylaws are the internal rules for the maintenance and operation of the corporation. It governs the acts of the incorporators, the board of directors, no, and other corporate officers. The requisites of the bylaws, in order for a valid bylaws to subsist, it must be consistent, of course, with the law and regulations. Hindi siya dapat nagko-contravene sa batas. And of course, the bylaws must also be consistent with the articles of incorporation. Now, if there is conflict between the provisions of the articles of incorporation on one hand and the bylaws on the other, then of course, it is the articles that should prevail. The bylaws must also be reasonable. It must not be arbitrary or oppressive. Like, for example, it is one thing if the bylaws require that the corporate officers come to work at 8 o'clock a.m., exceeding which late na siya, and then office hours shall terminate at 5 o'clock p.m. Pero pag yung tipong kinakailangan kapag na-late ang isang corporate officer, kinakailangan niya maglakad ng nakaluhod sa aisle, as provided by the bylaws. But that's already arbitrary. That is unjust. And therefore, that will affect the validity of the bylaws. And the bylaws must finally, and perhaps most importantly, must not disturb vested rights, impair contract or property rights of stockholders or members, or create obligations unknown to the law. To end the session, I would like you to pay close attention to the case of Salafranca versus Film Life Pamplona. This is the story of one Enrique Salafranca, who worked as an administrative officer at Film Life Village Homeowners Association since 1981. 1997, Film Life amended its bylaws. So yung posisyon ni Enrique, ni Salafranca, na administrative officer, ang nangyari because of the amendment, naging coterminous. Ibig sabihin nun, yung administrative officer, pwedeng tanggalin ng board of directors at their pleasure. So kung hindi na nila trip si Salafranca, pwede nilang sipain. This is of course opposed to yung regular employees na hindi mo pwedeng tanggalin without any basis. Kasi ang regular employee ay may security of tenure. There has to be a good reason in order to terminate an employee. Otherwise, kinakailangan niyang karapatan niyang magtrabaho or magstay sa kanyang trabaho until he retires. So ganyan na nangyari. Naging coterminous si Salafranca. And in 1992, tinanggal siya sa trabaho. Sabi ni Salafranca, I was illegally dismissed. I am a regular employee at hindi ako pwedeng tanggalin ng basta-basta ng ganun-ganun na lang. Now, the question of course brought to the Supreme Court is this: whether or not Salafranca was illegally dismissed. Sabi ng Supreme Court, yes, he was. Well, of course, sabi ng Supreme Court, admittedly, the right to amend bylaws ay nasa discretion ng korporasyon. The corporation has the power to change its bylaws as necessary. However, kagaya nga ng sinabi natin kanina, by way of limitation, the bylaws should not impair the obligation of existing contracts or rights. Hindi pwedeng mag-amend or mag-introduce ng bylaws na makaka-prejudice sa karapatan ng ibang tao. Ang problema kasi, regular employee na si Salafranca, hindi pwedeng through the amendment of the bylaws, biglang mag-downgrade yung kanyang employment. Regular employee na siya, which is the highest tier of employment. Kasi as a regular employee, you have security of tenure. If you have security of tenure, you can only be terminated for cause. Hindi ka pwedeng tanggalin kasi ayaw lang ng boss mo sa pagmumukha mo. Kailangan kang matanggal kasi meron kang ginawang masama o meron kang ginawang labag sa batas. Okay? So, ganun ang sinabi. If private responded, if Film Life wanted to make Salafranca's position coterminous with that of the board, then the amendment must take effect dapat after Salafranca's tenure, not during his term. So, yung amendment dapat, sabi ng Supreme Court, dapat mag-take effect lang yung change doon sa nature ng position ni Salafranca after Salafranca retires. Otherwise, sabi ng Supreme Court, Film Life's attempt to amend its bylaws is nothing but a devious but crude attempt to circumvent petitioner's right to security of tenure as a regular employee guaranteed under the labor code.